Also,
oh, wait, Your Honor, I don't have screenshots.
You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're gonna run into trouble with me real fast. Ms. Kirby, you may continue.
thank you.
There you go. There you go. What did I tell you? I'm done. I kind of tried to give my explanation. This defendant won't be quiet. It's March 9th, 9 a.m. Defendant's bond is revoked. Sir, when are you returning to the state of Michigan, or do you want me to come get you?
I will return Saturday morning to work at Michigan. Can it be Monday morning?
What time?
Please?
What time Saturday morning?
I think my flight gets in at 9:25 or something. I have to work at
Defendant's
12.
bond is revoked as indicated.
She beat me.
Defendant is.
How is this possible in America? I thought you were done. I have a delay on my phone. I thought you were done. There's a delay. I'm in St. Louis.
He's still talking to me.
I wasn't interrupting. I'm in St. Louis. I
I'm
can't.
done. Court calls case People versus Cameron Carter.
Well, Your Honor, John Vincent on behalf of the defendant, who stands to my right.
All right.
Say your name. Come on, Carter.
All right. We're going to deal with the bond hearing first and then decide if we're going to go with this case.
Okay. The people issued, sent in that motion because I was going to leave it in myself. There was 3 police reports made, 1 made to Romulus Police Department and 2 made to the Wayne County Sheriff's Office. I'm still awaiting the police reports from the Wayne County Sheriff's Office, but I received the Romulus Police Report and attached it to my emergency motion. There was text and things that were said by the defendant, threatening the life of the victim. When I spoke to her on the phone, she said she was extremely concerned for her safety, and I shared those concerns, which is why I filed a motion. I'm not sure why Mr. Carter has not turned himself in. This warrant and I would ask that the bond to be set at a very high rate, determined by the court and or to remain in one vote. These are 3 different violations of bond. He also has he has the no contact, he has the no go to that we have in this case, and so I don't understand what the reason to reach out for any reason.
Mr. Vince.
Well, Your Honor, is the witness here? Because that is all, and I mean, all the allegations are based on her words. There's been no police contact, no video, no third-party witness, no DNA, no fingerprints, no police contact with my defendant here.
So he wants a hearing on this bond violation?
None of these phone numbers connect to his account. He absolutely denies the allegations in here. There is no physical evidence, and if there is not a witness here, Your Honor, then both the underlying case should be dismissed and this alleged.
I'm not even talking about the underlying case. So just deal with what I told you to deal with.
All right, well,
does he want a hearing on the bond violation?
Absolutely, Your Honor.
When are you going to have the other report?
I'm not sure, but I can check on that today. I'm also waiting for the actual screenshots of the text messages that are written in the Romulus Police report. And if he's saying that that's not his phone number, I can also get a search warrant as to that effect.
In that police report, there are 6 phone numbers listed. The police report indicates that none of those numbers are Mr. Carter's. If there are screenshots, I have not received those screenshots. It's the first time I'm hearing that there are 2 other potential police reports out there. However, this police report says that 2 officers showed up. I don't know how a Wayne County Sheriff's Department police report would be any different than this, as far as I can see, there were no Wayne County sheriffs on the scene of this alleged incident. There's just simply no physical evidence. There's no third-party evidence. And frankly, if you read through the report.
I did. Before I revoked your client's bond.
Yeah, okay, well, I would hope you did. When you start to read through it, the allegations in there, either it's a lie, or he's the luckiest guy on the planet, because I would think that the Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened and find a purple Taurus. She says at 1 p.m. He began to call her, and it somehow got into an apartment, beat on the door of the apartment, left the apartment, came through the window, and generated somehow, all while outside, 6 other phone calls from 6 different numbers, none of which line up to the defendant. If she's not here, Your Honor, then I think that is a very, very strong indication that this is not factual. The other thing in this, Your Honor, this person alleges that he stole a gun from her in Pittsfield Township. Well, if that's the case, then shouldn't this have been a little higher priority? I think prosecution knows that this is not accurate. There's nothing before the court today to indicate that he is guilty of what they're saying he's guilty of. If she's not here, she should have been here. There's no Romulus police officers here, not that they saw anything anyway. There's no third party in the police report. It says witnesses, none. Wait a minute. He's broke into this apartment complex, banging on the door, goes outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that, especially at 2 p.m.? Without a witness, without some shred of physical evidence, there's nothing. This is just the allegations of someone who did not bother, apparently, to show up to court, both for this and presumably for the underlying charge.
First thing, this defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. He's also on bond awaiting pretrial where he's charged with child abuse force. He's also on bond awaiting a probable cause conference where he's charged with resisting and obstructing a police officer and fleeing third degree. Mr. Vincent claims that he knew nothing about screenshots, so I just said on the record I don't have them, I'm awaiting them. But they are in the Romulus police report. They say that they do have screenshots, so maybe he didn't read that report. Also,
oh, Your Honor, I don't have screenshots.
You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast. Ms. Kirby, you may continue.
Thank you. I also explained in my motion that the Romulus police report is different than the 2 other contacts that this victim had with the sheriff's department. I have included those police numbers. Those are also in the motion. So I'm not sure what he means on, I have no idea why the sheriff's department and Romulus were here. No, it's completely different. And I don't have the accusations in those. I'm awaiting to get those, given that they're not in our county, and I followed the process to get those. Also, this is, if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond a reasonable doubt for a bond violation. So I would ask the court to take what it has in front of it, including the Romulus PD report, and either adjourn so I can get the other police reports, and so I can get the actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be revoked and he to be remanded. Given the seriousness of this case and the seriousness of his other 2 cases, I do believe he's not only a threat to the victim, but to the safety of the community and also children. He seems to find it funny as his defense attorney speaks, which also tells me that he does not take this as serious at all, which also concerns me. As for the complaining witness not being present, I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware that he had a warrant out with no bond. So she is not present. Last time I spoke to her, she was in fear for her life. She said she would continue to answer the phone, but she has been placed in a different place that I know of the location that she does not want me to share out loud. I have no problem sharing that with the court. But she is not present, and regardless if she was present or not, I can still proceed based on forfeiture by wrongdoing with the interference that the defendant has committed himself through these other police reports. And I was going to ask for time to get those anyway, so that I could present those at trial. So regardless if she is here or not, and just for the record, the court rule does not actually say I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing. Thank you.
Anything else, Mr. Benson?
And if hearsay allegations, someone's not here. This all happened in the last 48 hours, 72 hours.
Simpson is not here, but if I look at what's in here, first of all, you're mixing two things. Because certainly they can proceed by hearsay as regards to bond violation. So that maybe we can clear that part up, because so they don't need her here for that. As to the final settlement conference, the people have stated to the court that they can proceed without her, if necessary, but that they also do know where she is.
I don't know how they could possibly proceed when there is not a
That's
stitch.
not your issue. They've made the representation to the court.
Okay, and I'm making a representation to the court that when you read the police report, which you have,
I read it.
then you know that there is only her allegation. At least for what I have in front of me and what you have in front of you. And he is here. He's availed himself to the court every time that I've had anything to do with him.
Why didn't he turn himself in between the time I revoked his bond and today? Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
Yeah, I mean, we were going to be here today.
That's not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if.
Oh, put me in handcuffs, man.
That's a wrong answer.
I'm sorry. I'm
Way the wrong answer.
sorry, man. Actually,
I'll deal with this in a minute, because right now I'm furious, Mr. Vincent, that you would represent that client defendant to remand. Take you. Court's gonna stand in recess. Maybe seated. Yeah. Can you bring him? Somebody back there with him? No. Can you bring him out? Court calls the case of the people versus Cameron Carter. Recall.
It was going to have to control.
Now, Vincent, on behalf of the defendant. Yeah, there was absolutely a mix-up. And as much as my understanding was that he had spoken to the court and they did not tell him to come in, and I should have come in. Yeah, it's absolutely a mistake on my part.
Well, it's not only a mistake, it's a sanctionable offense. And I think you ought to know that. To willfully tell a client or even to intimate to a client that they should in some way disobey a court order.
In no way, shape, or form, Your Honor, did I meant to have that effect happen. My understanding was that he had seen you in person this week and that you come to court from. I would never, and I think you know that about me, I would never have anyone try to knowingly or disobey an order. I would never knowingly disobey any of your bond conditions or orders. I don't know, Your Honor. This is a horrible mistake, and I'll fall on my sword for it. But it is a misunderstanding. It's not any. In no way, shape, or form was I trying to get him to avoid justice, and he certainly is trying to avoid justice on this, Your Honor. I understand that these charges and allegations are serious. I mean, all I can say, Your Honor, is that my understanding was that he had spoken to the court this week and that he was free to come here Friday. We clearly had, At no point did I ever advise Mr. Carter to do anything else other than follow the law. And must have told him that a dozen times, something that every time I've talked to him, do not violate your bond, don't violate your bond, show up Friday. That's when we have a court date. My understanding was that was the understanding. And it is absolutely a snafu on my part. And I beg the court's forgiveness. He has an appointment today at 2 p.m. to see Washington Community College counselor. He's trying to get his CDL so he can take care of his kids. He is working on another job. He's availed himself to court today, Your Honor. If this is bound over to jury selection, he'll be there then too. He understands this is serious, Your Honor. He's just vehement in his innocence, and I perhaps have been overzealous on my part. I meant no disrespect to you, the court, to the people.
What I'm going to do in this case, because, I mean, something's got to be decided as to what was told this defendant. That may have to be resolved some other way, but the court will take whatever action it deems necessary, and I won't do that until June 26th, if I deem it appropriate to do so, because as angry as I am right now, I'm not going to make that decision on that. I will set a bond hearing in person in this case for June 26, 2023 at 9 a.m. All of the paperwork will be sent over, and we can deal with it at that point. In the interim, defendant's bond is revoked. I will adjourn the jury final settlement conference that we were going to have today, as well as the jury selection. Jury final settlement will be my next one, August 11th, 2023 at 9 a.m. Jury selection, August 14th, 2023 at 8:30. Defendant's remanded.
Yeah, my echo.
I don't think you want to do that right now. I am just.
Your Honor, you know I did not.
Assistant Public Defender Kalina Anderson with on behalf of Mr. McGlashan. Mr. McGlashan, can you state your name again, please?
Brandon McGlashan, ma'am.
Your Honor, thank you again for the bench conference. At this time, the people are going to move to revoke the defendant's bond based upon the no contact violations that he's had with the victim in this case. I have previously disclosed to defense counsel the nature of the contacts, and there has been a new aggravated stalking case issued by my office that is in the process of sort of being sworn out and will be pending against the defendant soon. The defendant did have permission from circuit court to contact the victim regarding their child. However, the court has reviewed and has been submitted a police report that details the contacts he's had with her, which the people do believe go well past the scope of communications regarding the child, and are requesting at this time that he be remanded into custody because people have serious concerns that he will not leave the victim alone. He will continue to contact her. And while there is no threatening or violence alleged in any of these contacts, the people would certainly characterize them as harassing. And I do believe that it is appropriate at this time that his bond be revoked and he be remanded into custody. Thank you.
Response.
Thank you, Your Honor. In speaking with Mr. McGlashan, and we would indicate to the court that Mr. McGlashan does have permission to contact the complainant in this matter with regards to the child. A substantial amount of the conversations are about the child. They are to be, there were some communications to be made through the My Family Wizard app, but he was allowed to make contact via text if there was some emergency. There were some situations, without going into too much of an admission, but there was some situations where she was not responding on the Family Wizard. There were texts to get her to communicate with regards to the child. We would again reiterate, as we discussed in the bench conference, that there's no threatening behavior, no threats being made towards her, or any discussion about this particular case or anything to involving the case. My client has been the primary caregiver of the child, and while some of the things may not seem to be an emergency given his relationship with the child and him being the primary caregiver. He had a heightened sense of concern with regards to some of the things that were being discussed. The parties are currently in divorce proceedings. It's my understanding that they are trying to come to some resolution, and that my client is really just looking forward to moving forward, caring for his son, and continuing to work. Your Honor has given him permission to leave the state. He's in the state right now, is set to return on Saturday. And he does have another job where he will be working as an announcer at the water polo tournaments on Saturday and Sunday at the University of Michigan. So he is just asking for the court's consideration with regards to this. We've had substantial conversations as to how he is to handle any contacts that are made to him, and that he is not to respond. He's to get in contact with my office and allow us to deal with it without him responding. He understands that he's the one with the case and the PPO, and that, any contacts will fall on him. So he is just asking for some leniency from the court to be allowed to continue working and taking care of his child, and would ask that we adjourn this matter so that I can get the new case, see what's going on with that, and move forward.
Ms. Anderson, is there an opportunity for me to speak at all during this? Because
Mr. McGlashan, if the judge gives you permission, you can speak, but I would advise you not to speak about anything involving either case.
Sir,
even if
you can tell me. You can tell me what you want, and
Okay,
your
sir.
attorney gave you her advice.
Yes, she did. Your Honor, I'm not incriminating myself in any way here. I am verifiably, provably the victim of domestic violence from the person who got the PPO on me and kicked me out of my house. Miss Londy, the DA, is the one who received that evidence and gave me a very cold and short answer when I asked why my attacker was allowed to stay in my home and get a PPO on me. At the PPO hearing where they received the PPO, I got into evidence and a FOIA request that my wife does in fact have a violent history, including a no contest plea and 2 arrests after that.
Sir,
I'm just
sir,
saying, sir, she lied to kick me out. Is what I'm sorry. I'm sorry.
let me just stop you for a moment, because here's what I understand. You, as to the child or children in common, you had been directed by the family court to only make contact with through My Family Wizard.
Yes, sir.
And that the only exception to that was then if it were an emergency.
Or time sensitive, yes, not necessarily an emergency, but time sensitive regarding pickup or drop off, or something that needed to happen when she was dropping the kid off, like, make sure he brings this or that because we planned on doing this, that kind of thing. And if she's not answering, I would literally sent OFW. And I'm an idiot. I shouldn't ever respond to anything, but I feel like
sitting judge. Hold on.
Yes, sir.
You wrote to her. A sitting judge signed a protection order.
She wrote that to me, sir.
Hold on. That I acquired evidence that you were lying to get the PPO and to throw me from my house. And I literally gotten those documents that afternoon before you would not have gotten the order, and you know it. And just to be clear, I have gotten video transcripts of every hearing so that we can remind the judge of everything you said and done, and that she's not just relying on my memory. Sir, as
Yes,
to
sir.
even the parameter, because I'm going to give you a shot to tell me, and there are more.
I know, sir.
To explain to me in your mind how that fits into the sort of expanded parameters that the family court gave you over our parameters.
Honestly, sir, I don't really have a lot to say about that. I was just trying to explain my
I don't want. Tell me, sir.
You said how my mind.
Answer. If you want to talk to me, then you'll answer my question.
Yes, sir.
Because I'm trying to figure out, first of all, you were supposed to have no contact according to our case. That gets expanded because you're in these family court matters. The judge in the family court, everybody's in agreement, has said no contact except through my family wizard. And the only things outside of that are to be certain things. What I just read you, tell me how that fits into any of those things that constitute an exception.
I just honestly believed as a victim, if I screamed the truth loud enough, someone would come to my rescue. I don't know the system. I don't have a lawyer.
But that is not, hold
Yes,
on.
sir, I know.
That's not, that can't be a purpose for you contacting her.
I misunderstood the framing of the question. I'm sorry. I
The
just
framing of
honestly
my
believe-
question that I've said twice?
No, sir. Oh, sir. I'm sorry. I'm very sorry. I don't mean to agitate you. It's been a very long
I am not
year.
agitated. I'm just trying to give you every opportunity to explain to me some of these text messages
Yes,
and
sir.
how they fit within, you're before Judge Vandenberg,
Yes, sir.
how these,
I'm not 100% sure I can make a great case for that, sir. I've just been very willful and heartbroken and defiant, and I'm sorry.
Okay.
It will not happen
so,
again.
sir, there are, that was like one of the shortest ones. I don't
Yes,
know
sir.
what your legal fund has to do with an emergency.
With my legal what, sir?
Your legal fund that somebody's created for you. I don't know why that's an emergency.
Sir, I realize now through therapy that some of those things that I thought were things trying to get my wife to tell the truth before we had to come into this madness seem more manipulative and threatening than I had intended them to. I understand that. I'm working very hard to reframe things like that. All that stuff is literally just me
Yeah, but
trying
this
to
was
say,
after. Hold on. No. As I understand these emails, these text messages, these are occurring after everybody's told you what to do.
yeah, I'm not disputing that, sir. Again, I'm trying to answer the question, but I feel like the question is changing as I answer.
Oh, no, my question's not changing. I'm
Okay,
trying
it
to
doesn't
figure
fit,
out,
sir. It doesn't fit.
Sir,
It doesn't. Yes, sir. There's a delay.
if you want me to go through all of these and ask you for your explanation, I will.
I understand now what you're saying. Sir, I just want to do better. I have no explanation and it's not an excuse. I'm just heartbroken and I was trying to keep my family together and I'm not good at it. And it will never happen again.
Mr.
I swear to you.
Mr. McGlasson, again, I'm going to advise you just not to say anything further.
Yes,
It's not furthering our goal here.
Okay. I just want to do better. I'm sorry.
I'm going to adjourn this matter 1 week out to the 9th, 2023, 9 a.m. or as defendant's Zoom invite indicates. The court, having reviewed the text messages, understanding that it would be consistent with what Judge Vandenberg does, knowing the circumstances, allowing for emergencies, or even and giving the defendant here the benefit of the doubt, those things that are time sensitive. I read one example, but there are a number of examples through this thing that are not time sensitive. They certainly in this court's mind don't constitute at all an emergency. And quite frankly, and I get what counsel's saying in terms of threats, maybe a physical harm or something like that. But quite frankly, when I read through these, they are threatening. They're threatening, and you can phrase it maybe in terms of harassment, but they're really threatening in terms of getting a response.
Yes, sir.
And I mean, the other person on the other end, you want to keep talking? I'll let you keep talking.
No, sir.
No, it's up to you. It's up to you. I'm going to give you every shot to tell me what you want me to know.
I don't want to get in trouble, sir. I'm not trying to make you angry. I'm sorry.
I am not angry. I am trying to give you every opportunity to tell me. I just don't like being interrupted, but that doesn't make me angry. So Go ahead and tell me what you want me to say, because once I get going, I don't want to be interrupted.
I promise.
So
this is
you
the
go
last thing.
ahead.
Yes, sir.
Go ahead. Tell me what you want me to know.
My answer to every question will just be simply this. I naively thought that if I can prove I am the victim of an assault and getting kicked out of my house, that none of this would matter, that it would all just kind of be voided from the point where I can prove she lied and I'm an idiot. I'm sorry.
You done?
Yes, sir.
Bottom line, these don't constitute emergencies. They don't constitute something that needs a direct response or an immediate response from her or would be time sensitive. They are really an attempt to get someone to say something. They're actually like baiting types of emails to get her to maybe say something, or posturing maybe for his divorce case. That's not the purpose, certainly, of Judge Vandenberg's order. If, even as the defendant says, I wanted to get somebody to listen, I don't think she's the one that needs to listen. If he thinks he's been the victim of something, then he needs to get it to the prosecutor's office, police, whoever the heck he needs to get it to. But there you go. There you go. What did I tell you? I'm done. I kind of tried to give my explanation. This defendant won't be quiet. It's March 9th, 9 a.m. Defendant's bond is revoked. Sir, when are you returning to the state of Michigan, or do you want me to come get you?
I will return Saturday morning to work at Michigan. Can it be Monday morning?
What time?
Please?
What time Saturday morning?
I think my flight gets in at 9:25 or something. I have to work at
Defendant's
12.
bond is revoked as indicated.
She beat me.
Defendant is
How is this possible in America?
Defendant is to turn himself into the Washington County Jail by noon this Saturday, which is the 4th. And sir, when I'm telling you, so we don't have to play around the edges of what I mean. If it's 12:01, you're going to have a problem with me.
Yes, sir.
12 noon. If defendant fails to return himself in, a bench warrant will issue for his arrest and he will be held without bond. I told you what rules I play by. You still wanted to interrupt me? I'm telling you the rules now. Try me. Thank you, counsel.
Sir, I thought you were done. I have a delay on my phone. I thought you were done. There's a delay. I'm in St. Louis.
He's still talking to me.
I wasn't interrupting. I'm in St. Louis.
I'm done.
Mr.
I'm
McGlashan,
done.
just log off, Mr. McGlashan. We'll talk later.
This courtroom exchange centered on two separate bond violation proceedings in which prosecutors argued that both defendants had violated court-ordered no-contact conditions. In the first case, the prosecution presented police reports and allegations that the defendant had repeatedly contacted and threatened the alleged victim despite existing bond restrictions. Defense counsel challenged the credibility of the allegations, emphasizing the lack of physical evidence, witness testimony, and direct proof linking the defendant to the reported communications. However, the judge focused heavily on the defendant's failure to surrender after his bond had been revoked and expressed serious concern that defense counsel had seemingly advised the defendant to simply appear at the next court date rather than immediately comply with the court's order. Finding the situation unacceptable, the judge revoked the defendant's bond, ordered him remanded into custody, and scheduled a future hearing to examine the alleged bond violations in greater detail. In the second case, the court reviewed evidence that a defendant accused of violating a no-contact order had repeatedly sent messages to the protected party beyond the limited communication permitted by family court orders. Although the defense argued that many contacts concerned childcare matters, and contained no direct threats. The judge concluded that numerous messages were neither emergencies nor time-sensitive issues and appeared intended to pressure or provoke a response. Determining that the communications violated the spirit and terms of the court's restrictions, the judge revoked the defendant's bond and ordered him to surrender to jail, warning that any failure to comply would result in further legal consequences.